three issues that augmented reality companies should be thinking of are obviously a huge one is privacy. Because in augmented reality you have to capture your user's environment in order to then augment the environment. Capturing that environment captures not only their information but information of people around them, and that poses a problem in some jurisdictions, for example Europe, where they're much more strict about privacy, much more serious about privacy, or restrictive, I guess, than the US. There are also some state-by-state privacy laws as well. And then Child Protection Act issues, right? If you're capturing images of minors, for example, in the U.S., that can be a problem, or depending on how you're using those issues. A second aspect that comes with the privacy is data protection. So if you're capturing user data, how are you protecting that data, and what are the steps you take if there are a breach? Because augmented reality provides platform providers so much information about their users. If you're housing or using that information in any way and any of that's breached, you have to have procedures in place for what you're going to be doing. The last one that we see, and this is just kind of across all the newer business models when it comes to extracting spend from users, is virtual currency and stored value. If you're doing kind of a free to use or a freemium model, there may be some money transmitter or payment issues that come into play as you're asking users to kind of pay for individual services and hold their stored money, and then that they can then use to pay for individual services.
And so what would be some of the issues around that payment and currency stuff?
The way that anytime you have kind of a freemium model where users buy in, right, and they buy like gems or they buy points that can then be redeemed for kind of upgraded services within a service, that falls under stored value. So it's the same as if I go to Best Buy and buy a Best Buy card. And there's all kinds of issues, there are all kinds of legal kind of hoops that you need to jump through to make sure that you're, before you can kind of cancel out people's credit, what you have to do, how long you have to hold it. Those kinds of stored value issues. The Card Act, there was a Card Act that was written, I think it was about 5 or 6 years ago now, that kind of updated the laws and really had hoped to update it for the purposes of virtual currency, but there are still kind of some artifacts that go back to the fact that this is not directly analogous, right, to these kind of stored gift cards that people give out to each other.
So are the laws trending towards being more sort of stringent or more loose in terms of what companies who want to innovate can do?
I would say that the laws are fairly static, and although they don't apply directly to virtual currencies, it's close enough you can kind of figure out the right way to do it. The thing is, there aren't a lot of attorneys that practice a lot in that space, in stored value space. I'm not an expert in it by any stretch of the imagination. So making sure that you're working with counsel who is aware of stored value rules and is familiar with the kinds of things that would trigger, for example, you to need like a money transmitter license or to work with someone who has a money transmitter license, which is the case anytime you're kind of exchanging credits between users, which some services do. You want to be aware of those. A further issue that goes on when it comes to kind of the same kind of freemium models where you store some kind of value for users is if you're having any kind of contests where you're giving away that kind of value, you need to make sure that you don't fall under kind of regulated gaming, or you don't fall under the sweepstakes contest laws, which are state by state, and some of them require you to post a bond over a certain value and all kinds of issues like that. So one of the things that companies who are leveraging social media to do marketing should be aware of is that FTC guidelines require that endorsers, anytime they're receiving compensation for their endorsement, that they disclose that compensation. So in other words, if I'm going to say I love Ford vehicles, and by the way, Ford's paying me $2,000, I need to make that compensation clear. This becomes an issue for example, any site where it says, email this to your friends or send this out on Twitter and receive $25 off your next purchase or whatever. If that email or that tweet is considered an endorsement, and I'm not disclosing that I may receive $25 off my next purchase, but for doing that, I'm violating FTC guidelines. Now it's doubtful that the FTC is going to come against me as an individual just for sending an email to 25 friends saying I like this particular flash sale site. They're not going to enforce against me. They're going to enforce against the flash sale site that's asking me to do this and isn't creating a mechanism for me to disclose, right? Because it would be very easy to put in an email and because I'm sending you this email, if you join, I'll get $25 off of my next purchase. And as long as you do that, then it's no problem. The problem isn't paying for an endorsement. The problem is not disclosing the relationship between the endorser and the endorsee.
Has the FTC gone after any of these companies? Because I feel like every website I know that sells stuff now online, like, not specifically Warby Parker, but just like the new generation of direct-to-consumer sort of clothing companies, product companies, are all about the bounty sharing.
Absolutely. So there actually have been a couple of FTC enforcements where they've approached companies, and companies have had to comply. And the problem is that in some formats, it's not easy to disclose that relationship. So, for example, to extract a Facebook like from users, how are you then able to get a disclaimer that users disclose that they're giving this like in exchange for something? That's a very difficult thing. I mean, you can maybe request users to post on their walls they've liked this because they like this company and they will be receiving this compensation for the like. You could ask them to do that.
So you as a company, could you protect your back if you just do something as simple as that? Hey, when you like us, even though nobody's going to do it, just at least to post it?
Well, I think at the end of the day, even the FTC are human beings, right? And so when they see that the format that you're requesting endorsements from does not allow for the kind of disclosure that you would like to see, but you see the company putting forth a good faith effort to at least educate the endorsers on their duty to disclose that to the public, I think that is going to go a lot further to getting in their good graces than a company that's not doing it. Another one would be, for example, reviews on the App Store. Submit a review and get 30 gems in the game. In that case, you're asking them just to rate, so it's not necessarily an endorsement, but it could be considered an endorsement. For example, iOS doesn't provide a mechanism for you to auto-populate the review. By the way, receiving 30 gems for this review. But if you were to put something in your little pop-up that said, do this and you'll receive 30 gems in your review, please note that you are receiving 30 gems for this thing. It's probably not what the FTC would love, but at the same time, it's a good faith effort on the part of the company to fulfill their duty and to let the endorser know what their duty is.